Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023 section 162 to 168, that is refreshing memory.
हेलो एवरीवन एंड अ वेरी वार्म वेलकम। आज हम डिस्कस करेंगे सेक्शन 162 ऑफ द भारतीय साक्ष्य अधिनियम 2023। ये सेक्शन डील करता है एक बहुत ही इंटरेस्टिंग कॉन्सेप्ट से जिसे कहते हैं रिफ्रेशिंग मेमोरी। नाउ फॉर योर जुडिशरी एंड एपीओ एग्जाम्स दिस सेक्शन इज एब्सोल्युटली क्रूशियल, सो लेट्स डाइव राइट इन।
So, here's our game plan for today. We'll start with a basic introduction to Section 162. Then, we'll break down its essential components. After that, we'll see how it works in a real courtroom, compare it to the old law, which is very important, understand the legal principles behind it, and finally, wrap up with some key revision points for your exams.
All right, let's start with the introduction. You know, it's just a simple fact of life that human memory isn't perfect. It fades over time. In court, getting accurate testimony is everything. But think about it. How can you expect a witness to remember every single detail of something that happened maybe months or even years ago?
Well, to tackle this exact problem, the law gives us a solution, Section 162. This section creates a legal pathway. It allows a witness, right there in the middle of their examination, to look at certain documents, like notes or a diary, to jog their memory. The whole point is to make sure the testimony they give is as accurate and reliable as possible. Okay, now for the important part. Let's really dig in and decode the essential ingredients of this section. These are the building blocks of this entire provision, and you absolutely need to have a clear understanding of them for your exams.
So this is the text directly from the act itself. Now, what does it mean in simple language? सिंपल भाषा में इसका मतलब है कि जब एक विटनेस कोर्ट में गवाही दे रहा हो, तब वो उस डॉक्यूमेंट को देख सकता है जो उसने खुद ट्रांजैक्शन के टाइम या उसके तुरंत बाद बनाया था।
As you can see in this table, there are 5 key elements here. First, this whole rule only kicks in when a witness is under examination. Second, they can refer to a writing, but it has to be one they either made themselves or one that someone else made which they then checked and verified. Third, and this is critical, is the time requirement. The document must have been made contemporaneously, that is, at or very soon after the event. Fourth, copies can sometimes be used, but only if the court gives permission. And finally, there's a special rule for experts who can refresh their memory by looking at professional books or treatises. Let's quickly walk through how this happens in court. So, step 1, the witness is on the stand. Step 2, they ask to look at a document they made at the time of the incident. Step 3, the court will check the document's authenticity and the witness has to confirm that it's accurate. And only after all these checks and balances, in step 4, is their memory considered officially refreshed for the purpose of giving testimony. Theory is great, but let's see how this actually works in practice. We'll look at the real-world application of this section with a simple example and an important landmark case. Let's take a very straightforward scenario. Imagine a witness saw a road accident. In court, a few months later, they can't quite remember the car's license plate number, but right after the accident, they had jotted it down in their diary. Under Section 162, the court can allow them to look at that diary entry to provide the correct number. It's as practical as that. This isn't just theory. It's backed by our judiciary. In the landmark case of State of Gujarat v. Mohanlal Jidamalji Porwal, the court said something very important. It recognized that using documents to help a witness is a practical necessity to get to the truth. The court basically acknowledged that you can't always expect perfect human memory.
All right, everyone, I need your full attention here. This next part is extremely important, especially for all of you who are studying the new criminal laws. We need to compare this new section with the old one.
Please make a note of this. The concept of refreshing memory was earlier under Section 159 of the Indian Evidence Act of 1872. Now, it has been replaced and renumbered as Section 162 of the Bharatiya Sakshya Adhiniyam 2023. Don't make this mistake in your exams. The new section is 162 of the BSA, not 159 of the IEA.
You know, every law has a why, a core philosophy behind it. So what's the guiding principle that forms the foundation of Section 162? Let's take a look.
The whole idea can be summed up in a simple, powerful maxim. Memory may fade, but records remain. It's a beautiful way of saying that while our memories can get blurry, a written record is permanent. And that's why the law places so much importance on documents that were created when the memory of the event was still fresh and clear.
Okay, let's shift gears now to the most critical part for all you aspirants, our exam-ready revision. These tips are designed to help you score those crucial marks in your judiciary and APO exams.
So, for your prelims, you can definitely expect a direct question on Section 162, or perhaps its key ingredients. They might even try to trick you by asking about the old section number, 159 of the IAA. Now, for your mains exam, be ready for a problem-based question. They might give you a scenario with a witness and a document and ask you to apply the law. A short note on refreshing memory is also a very common question.
For a super fast revision, just lock these 3 things in your mind. First, the section number. It's Section 162 of the BSA 2023. Second, the core concept. It's all about refreshing memory using a document made at the time of the event. And third, exam importance. It is extremely high for both your prelims and your mains.
And finally, as we wrap up, I want to leave you with a question to think about. If a witness can refer to notes, how does the court make sure this doesn't turn into an opportunity for them to give false or fabricated testimony? Think about the safeguards that are built into this process.
For more such exam-focused legal content for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we are diving into a really important topic for your judiciary and APO exams. We're talking about Section 163 of the new Bharatiya Sakshya Adhiniyam 2023. This section deals with a very practical situation in court. What happens when a witness has to testify about a document, but honestly, they just can't remember the specific facts inside it? So, picture this. A witness is on the stand, maybe years after something happened. They're asked about the details, but their memory's blank. Is their testimony now completely useless? Does the court just throw it out? Well, this is the exact problem that Section 163 is here to solve. Let's dig in and find out how. In this explainer, we've got a clear roadmap. We'll kick things off with an introduction to Section 163. Then we'll break down its essential components. After that, we'll see how it's actually applied in court. And finally, we'll wrap it up with an exam perspective to make sure you're ready to score those marks. Okay, let's start with the basics. Section 163 is really a natural follow-up to the ideas we see in Section 162. It specifically zooms in on those cases where a witness's memory has faded over time, but thankfully, they have a reliable document that they can fall back on. Now let's look at the BEAR Act. It says that a witness can testify about facts in a document even if they don't have any specific memory of the facts themselves. But, and this is the most important part, there's one huge condition. They have to be absolutely sure that the facts were written down correctly in that document at the time. To really get how this section works, we need to take it apart and look at its building blocks. So let's deconstruct it and examine the core ingredients of Section 163. Take a good look at this table. For Section 163 to even come into play, every single one of these conditions has to be met. First, there must be a document that fits the criteria of Section 162. Second, the witness genuinely has no independent memory of the facts. Third, the witness is completely confident that the document is accurate. And finally, their testimony is coming directly from that document. The key takeaway here is that all these ingredients must exist together.
So that's the theory, but we all know theory is one thing and practice is another. Now let's see how this all plays out inside a real courtroom. How do we go from the textbook to the witness box?
The process is actually pretty logical. The witness takes the stand. When they're questioned, they admit they can't recall the specific details on their own. At this point, with the court's permission, they can refer to the document made back when the event happened. As long as they can assure the court of the document's accuracy, they are then allowed to give their testimony based on what's written in it. The act itself gives us the classic example of a bookkeeper. Let's say a bookkeeper is in court, and they're asked about a transaction that happened a year ago. Of course, they're not going to remember every single debit and credit. But they can testify by looking at their ledger as long as they are certain that all those entries were made correctly at the time.
And you can see this principle everywhere in real life. An accountant looking at ledgers, a doctor testifying about a patient's history by referring to their case file, even if they don't remember that specific appointment. A police officer can refer to a statement they recorded or their case diary. A manager can confirm details of a sale by checking the invoices. This really shows just how useful this section is.
The courts have also strongly supported this idea. You should definitely know these two cases. In Haral Vispad Kulal, the court said that records made in the regular course of business have very high evidentiary value. And in State of Bihar vs. Radha Krishna Singh, the court pointed out that a reliable document is often much better than a person's fading memory.
You know, this whole section is built on a really simple but powerful idea. Records speak when memory fails. What this means is that the law values the reliability of a properly kept record more than the shaky, fallible nature of human memory. So the bottom line is reliability over recollection.
Okay, let's switch gears and focus on what's probably on everyone's mind, the exams. How is this section important for you, and how can you use it to score high in your judiciary and APO exams? Now listen very carefully. This is a classic trap in exams. This same rule used to be under Section 160 of the old Indian Evidence Act, 1872. Now, under the new Bharatiya Sakshya Adhiniyam, 2023, it is Section 163. Please do not make this mistake. Old law, Section 160. New law, Section 163. This is a very likely direct question for your prelim. If you get a question in your mains exam about the evidential value of this section, these are the points you want to highlight. It allows testimony even when memory fails. It hinges on the accuracy of records made at the time. It gives more weight to documentary evidence, and it's absolutely essential for cases involving business deals and official records. So here's a quick exam tip for you. In your judiciary prelims, expect a direct question about the section number or its main idea. But for mains, you should be ready for a problem-based question, something like the bookkeeper or doctor example, where you'll have to decide if the testimony is valid or not.
All right, let's do a super quick revision. If you remember nothing else, remember these three things. First, the section number. It's Section 163 of the Bharatiya Sakshya Adhiniyam 2023. Second, the core concept. Testimony is valid if it's based on an accurate document, even if the witness can't remember. And third, the key principle. The reliability of the record beats the recollection of the witness.
I really hope this gives you a crystal clear understanding of Section 163. For more legal explainers focused on your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we are diving deep into a section from the new Evidence Act that you absolutely have to know for your judiciary and APO exams. Let's get right into it. So here's what we've got on the agenda. We'll start with a quick introduction, break down the key parts of the law, see how it's actually used in court, look at some important legal principles, and then, of course, we'll wrap up with some focus tips for your exams. All right, let's begin. Our focus today is on a rule that's all about one thing: fairness. It might sound like a small procedural point, but trust me, its impact in the courtroom is huge. Okay, so today we're discussing Section 164 of the Bharatiya Sakshya Adhiniyam 2023. And please note the name of this new act very carefully. This section comes from Chapter 11, and it's really all about making sure evidence is handled correctly to ensure a fair trial for everyone involved. Now, I know the Bare Act language can feel a bit technical, right? So what does this actually mean in simple terms? Well, it's pretty straightforward. If a witness is on the stand and uses any kind of document to refresh their memory, the other side, the opposing party, has an absolute right to see that document. And not just see it, but also question the witness about it. Now, to really master this for your mains answers, we have to break this section down into its core parts. Understanding these ingredients is going to be essential for writing a top-notch response. So you can think of this section as having 5 key elements. First, you need a witness who's using some sort of written document. Second, the other party has a right to look at it. Third, and this is important, it's not a request. Producing the document is mandatory if they ask. Fourth, this gives them the power to cross-examine the witness based on what's in that document. And finally, why do we do all this? To ensure total transparency in the courtroom. No hidden notes, no secret papers. Okay, so that's the theory, but how does this all actually play out in a real courtroom? Let's look at the practical side of things. The whole process flows in these 4 simple steps, as you can see. A witness glances at a document to remember a detail. The opposing lawyer sees this and says, "I want to see that." The document has to be handed over, and boom, the lawyer can now start asking questions based on what's written in it. Simple as that. Let's make this even clearer with some real-world examples, the kind you might see in a problem-based question. Imagine a police officer is testifying and looks at his case diary. The defense lawyer can immediately ask to see it. Or picture a doctor in an accident case who refers to the patient's notes. The other side has the right to inspect those notes. These are classic situations where Section 164 comes into play. All right, let's dig a little deeper now. We've seen how the rule works, but why does it exist? Every good law has a strong foundation, and Section 164 is built on some really important judicial principles and landmark cases. You know, this whole idea can be summed up with a famous legal maxim, audi alterum partem. It's a Latin phrase that just means listen to the other side. It's a cornerstone of natural justice. You can't have a fair trial if one side is using evidence that the other side can't even see, let alone challenge. So Section 164 is really just this principle in action. And this isn't just an abstract idea. Our courts have strongly supported it. Just look at these landmark cases. In judgments like State of Kerala versus Babu and Not Worth Saying versus the Director of Enforcement, the Supreme Court made it crystal clear. A fair chance to cross-examine isn't just a suggestion, it's a right. And that right means nothing if you can't see the documents being used against your client. So we come to the most important part for you. How do we take all this information and turn it into marks on your judiciary and APO exams? Let's focus on that right now. Okay, everyone, please pay close attention here, because this is probably the most critical slide for your exams. This exact rule used to be under Section 161 of the old Indian Evidence Act. Now it has been replaced and is Section 164 of the Bharatiya Sakshya Adhiniyam 2023. The idea is the same, but you absolutely must not write the old section number. I repeat, do not make that mistake. You have to quote the new section number. This is a common trap, so be prepared for it. So how do you tackle this in your exams? For the prelims, you can expect a direct question on the section number or its main idea. For the mains, be ready for a short note or a problem-based question, maybe using one of those examples we talked about earlier. And here's a pro tip. Whenever you write about Section 164, always connect it to the principles of natural justice. It'll make your answer much stronger. All right, let's do a super quick revision. If you remember nothing else, remember these 3 things. 1. The section is 164 of the Bharatiya Sakshya Adhiniyam 2023. 2. The main idea is the right to inspect documents used by a witness. And 3. The legal principle behind it is the right to a fair hearing. Simple, right? And its exam importance is very, very high. And that wraps up our deep dive into Section 164. I really hope this explainer has helped clear things up for your preparation. For more legal content focused specifically on your exams, make sure you stay connected with us right here at Ganga Education. But before we go, here's a little something to think about. This right to inspect is powerful, but could it sometimes give the other side an unfair advantage by letting them see a witness's private notes? It's an interesting question. Pondering it from both sides will really help you build a more critical understanding of the law. In today's session, we're going to tackle a really important section from the brand new Bharatiya Sakshya Adhiniyam 2023. We're talking about Section 165, all about the production of documents. Now, this is a topic that's not just a game changer in the courtroom, it's also a high-yield area for your judiciary and APO exams. So let's get right into it. All right, so here's our roadmap for today. We'll start with the basic rule of Section 165. Then we'll dissect the section to understand its core ingredients. After that, we'll explore the ultimate power the court holds, but also the limits and exceptions to that power. We'll also touch upon some landmark judicial interpretations, super important for your mains. And of course, we'll wrap it all up with a sharp focus on what you need for your exams and a quick summary. So, let me ask you this. Just imagine for a moment, there's a crucial document, a piece of evidence that could turn a whole case around, and it's right there, in a witness's hands. But when they're asked to show it in court, they simply refuse. They object. What happens then? Can they just hide the evidence? Well, this is the exact situation Section 165 is here to handle. Okay, let's get into the nitty-gritty of Section 165 of the Bharatiya Sakshya Adhiniyam 2023. At its core, this section is all about a delicate balancing act. On one side, you have the court's primary duty, to find the truth. But on the other side, there's the need to protect the public interest. So this section is the mechanism that ensures key documents get to the court and that no one can just hide away crucial evidence. So let's look at the actual words of the law. The Bare Act says a witness shall bring it to court, notwithstanding any objection. Now, as law students, when the law says shall, it means must. It's not optional. So no matter what objection the witness has, they have to bring it to court. It's compulsory. But here's the key distinction. Just bringing it to court doesn't automatically make it evidence. That's a whole other ballgame, and that decision rests solely with the judge. All right, now let's break this section down into what I like to call its essential ingredients. Pay close attention here because understanding these components is absolutely crucial for your exams, particularly for structuring those high-scoring answers in your mains. This table really lays out the whole shebang. Let's walk through it. First, you need a proper legal order, a summons to produce. Second, the witness must actually have the document. It needs to be in their possession or power. Third, and this is non-negotiable, production is mandatory. The witness literally has no choice but to bring it. And fourth, this is the real power move here. The witness doesn't get to decide if their objection is valid. Only the court can do that. The entire power rests with the judiciary. So, we've established the court has this ultimate power. But how does it actually work in practice? Let's look at the step-by-step process. This really clarifies the flow of how things happen in the courtroom. Yeah, this makes it crystal clear. Step 1, the summons is issued. Step 2, the witness, as we've said, must bring the document to court. Step 3, this is where an objection comes in. Now, what happens? Step 4, the court can actually look at the document in private to see if the objection has any merit. And finally, Step 5, the court makes the call on whether it's admissible as evidence. The big takeaway? The court is the ultimate gatekeeper. Okay, theory is one thing, but let's make this real. We'll use a practical example, exactly the kind of problem-based question you're likely to face in your exams. This will help solidify the concept. Okay, let's say A and B are in a business dispute. The court summons A to produce a specific contract, but A objects, arguing, "Your Honor, this contract has our trade secrets in it." So what happens now? Well, as per Section 165, A has no choice. They must bring the contract to court. Then, the judge will take that contract, look at it privately, and decide two things. First, is this trade secret claim legitimate? And second, based on that, should this document be admitted as evidence? See how it works? So, we've been talking a lot about the court's immense power to compel production. It seems almost unlimited, right? But it's not absolute. The law is smart. It builds in some very important safeguards to protect really sensitive and confidential information. And these exceptions are laid out right there in Section 165. First up, we have matters of state. The court cannot inspect documents that deal with confidential, unpublished state affairs. Think national security. Second, presidential communication. Any communication between ministers and the President of India is completely privileged. You just can't compel its production. And third, there's a provision for confidential translation. If a document needs to be translated, the judge can order the translator to keep the contents totally secret. All right, let's shift gears and look at some landmarked judicial interpretations. And I want to emphasize this. Citing relevant case law in your mains answers is what separates a good answer from a great one. It really shows the examiner you have a deep understanding of the law. Okay, there are two key cases you absolutely need to know here. The first is State of Punjab versus Sodhi Sukhdev Singh. This case established the principle of public interest immunity. But then came the landmark case, S.P. Gupta versus Union of India. You probably know it as the first judge's case. Here, the court looked at governmental privilege more critically and emphasized the need for disclosure and transparency. You can see the evolution in the court's thinking. You know, the core idea behind protecting state secrets can be summed up in a very powerful legal maxim: Salus populi suprema lex. It simply means the welfare of the people is the supreme law. The thinking is that sometimes protecting the public interest by keeping certain government matters confidential is the highest duty, even if it means a particular piece of evidence can't be used in a specific case. Okay, everyone, let's get down to brass tacks. This is probably the most important part for you, the exam focus. Let's laser in on exactly what you need to remember to maximize your marks on this topic. Now please pay very close attention to this slide. This is a classic trap. Under the old Indian Evidence Act of 1872, this was Section 162, but now, under the new Bharatiya Sakshya Adhiniyam 2023, it has moved to Section 165. I cannot stress this enough. Getting the section number wrong, especially in your mains paper, is a simple mistake that can cost you dearly. It's Section 165 now. And here's another pro tip. Notice the cross-reference here. Section 165 itself tells us that if a translator breaks their oath of secrecy, they've committed an offense. But where is that offense defined? It's in Section 198 of the Bharatiya Sanhita 2023. Connecting the dots between different acts like this, that's what shows the examiner you've done your homework thoroughly. So, to sum up your exam strategy, for your prelims, be ready for direct questions. They might try to trick you with the old and new section numbers. For your mains, you need to go deeper. Expect a problem-based question where you have to discuss objections, admissibility, or privilege. You'll need to apply all the principles and case law we've talked about. All right, let's do a super quick revision. If you remember nothing else, remember these 3 things. 1. This section is now Section 165 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core concept is simple. Production is compulsory, but admissibility is the court's call. And 3. This section is extremely important for both your prelims and your mains. So when you think about it, Section 165 really shows us the immense power and the great responsibility that our courts hold. It gives them the tools to seek the truth, but it also trusts them to be the guardians of the public good. It leaves us with a deep question to ponder. How do we balance an individual's right to a fair trial against the security of the entire nation? For more judiciary, APO, and law exam-focused legal content, stay connected with Ganga Education. Hello, everyone. Today, we're going to be discussing Section 166 of the Bharatiya Sakshya Adhiniyam 2023. This section deals with documentary evidence and is incredibly important for both the judiciary and APO exams. Now, pay close attention. This is the new act, so its section number is different from the old law. So let's start with a situation. Imagine a lawyer asks the opposing party for a document. They get it, they look it over, and then realize it's actually not very helpful for their case. Can they just decide not to use it? In other words, can they go window shopping for evidence? Well, Section 166 gives us a very clear answer to that. To really master this section, we're going to follow a clear path. We'll start with the core rule, then we'll decode its essential components. After that, we'll see it in action with practical examples and case law, understand the legal principles behind it, and finally, we'll do a quick revision for your exams. So, let's begin with the first part, the core rule. At its heart, this section was created to ensure the fair use of documentary evidence inside the courtroom. Again, just to be crystal clear, we are focusing on Section 166 of the Bharatiya Sakshya Adhiniyam 2023. Make sure you remember this new section number. The language of the BEAR Act is very clear. In simple terms, it means that if you give notice and ask the opposing party for a document, and once it's produced, you inspect it, you can't refuse to present it as evidence if the other party demands it. At that point, you are legally bound. Now that we understand the basic rule, let's break it down into its essential components. This is a very critical step, because before any court applies a legal provision, it first verifies these essential ingredients. There are 4 important elements in this section. First, a notice to produce a document must be given. Second, the document must actually be produced by the other party. Third, and this is the most crucial part, the party who called for the document must inspect it. If these 3 conditions are met, then the 4th element is activated, the obligation to produce it as evidence if the producing party makes that demand. You can look at this procedural flow like a chain of events. Step 1, a notice is given. Step 2, the document is produced. Step 3, the most important one, the document is inspected. That inspection is the key that unlocks Step 4, making the duty to present that document as evidence binding. It's an unbreakable sequence. Understanding theory is important, but the law really comes alive through practical application. So in this next section, let's see this principle in action through a common legal scenario. Let's take a very common situation, a dispute in court between 2 parties over a contract. In such cases, documentary evidence, like the contract itself, is extremely critical. Party A sues Party B and gives notice to produce the original contract. Party B presents the contract. Now, Party A's lawyer inspects it and finds that some clauses are favorable to their case, but others are quite damaging. So can they just show the judge the good clauses? Absolutely not. If Party B insists, Party A is now bound to submit the entire contract as evidence. The crucial point here is simple: no cherry picking. And this isn't just some rule in a statute book. It's a fundamental principle that our courts, all the way up to the Supreme Court, have consistently upheld. In the landmark judgment of Harilal versus Badkulal, the court affirmed this exact principle. The court emphasized that evidence must be used fairly. You cannot rely on only the part of a document that suits you and ignore the rest. The document must be considered in its entirety. Similarly, in the case of Kalia versus the state of Madhya Pradesh, the court again stressed the need for a proper and complete evaluation of documentary evidence. This further strengthens the legal spirit behind Section 166. So we've looked at the what and the how of Section 166. But now the question arises, why? Why does this rule exist? This question takes us to the fundamental legal principles that give this section its judicial strength. This principle can also be understood through a legal maxim, quae approbat non reprobat. Its simple meaning is, one who accepts cannot later reject. When you inspect the document, you have, in a legal sense, accepted it. You cannot later reject it simply because it doesn't suit your case. This maxim perfectly illustrates the foundation of Section 166. So what is the ultimate evidential value of this section? Well, it's a powerful tool for justice. It prevents the suppression of evidence and selective reliance on facts. It ensures transparency and a fair trial for both parties. And finally, it promotes the complete disclosure of all relevant facts before the court. All right, let's move on to the most critical part, especially for all you aspirants, our exam quick revision section. Here, we'll focus on the things you absolutely must remember for your papers. Here's a very important exam tip. In the judiciary prelims, you could be asked a direct question on the section number. In the mains exam, however, you can expect a problem-based question, just like that contract dispute scenario, where you'll have to apply the principles of Section 166.
So for a quick revision, always remember these three things. First, the section number 166 of the Bharatiya Sakshya Adhiniyam 2023. Second, its core concept, no cherry-picking evidence after inspection. And third, its underlying principle, fairness and complete disclosure. These 3 points are very important.
And with that, our explainer for today comes to an end. I'll leave you with a final question to think about. How does a seemingly simple procedural rule become such a powerful safeguard against misuse in our pursuit of justice? For more legal content focused on judiciary, APO, and other law exams, stay connected with Ganga Education. Today, we're going to tackle a really critical section for your upcoming exams. Section 167 of the Bharatiya Sakshya Adhiniyam 2023. Now listen very carefully. This is the new act. It replaces the old Indian Evidence Act. So please, don't get confused with the section numbers. This explainer is specifically designed for all you law students and judiciary aspirants who absolutely need to master these new provisions. All right, let's get started. Here's our game plan for today. We'll begin with a quick intro to Section 167, then we'll break down its core rule. After that, we'll see how it's actually applied in court, look at some key principles and judgments, and most importantly, we'll figure out why this is such a high-yield topic for your exams. And of course, we'll wrap it all up with a quick revision to make sure everything sticks. So let's jump right in. What is Section 167 all about? Well, at its heart, it's about maintaining discipline and fairness when it comes to presenting documents in court. Think of it as a procedural safeguard that ensures a level playing field for both parties during a trial. The main idea here is to prevent something called a trial by ambush. You know, the section stops one party from strategically hiding an important document, letting the other side present their entire case, and then, bam, suddenly bringing out that hidden document to get an unfair advantage. The whole point of Section 167 is to uphold transparency and fairness in the trial process. Now, let's get into the nitty-gritty and deconstruct the legal language of this provision. By breaking it down into simple parts, we're going to get a much clearer picture of what it really means and how it's applied. So, this is the text straight from the BEAR Act. Let's read it together. When a party refuses to produce a document which he has had notice to produce, he cannot afterwards use the document as evidence without the consent of the other party or the order of the court. Seems pretty straightforward, right? But trust me, the secret to mastering this section is understanding its essential ingredients, which is exactly what we're going to do next. This table lays out the main components perfectly. First, you have the notice to produce. That's the formal request. Second, you have the refusal. If those two things happen, the third component gets triggered, the bar on subsequent use. Basically, the party that refused now faces a penalty. But there is a kind of escape hatch, which is the exception. If the other side says okay, or if the court itself gives an order, the document can still be used. Understanding this procedural flow is absolutely crucial. As you can see, it's a clear cause and effect chain. Party A gives a notice, Party B refuses. The direct consequence for Party B? They can't use that piece of evidence. The only way out is through Party A's consent or a special permission from the court. Getting the structure down is so important for writing effective answers in your mains exam. Okay, now that we've got the theory down, let's see how Section 167 actually works in a real-world courtroom setting. How is it applied in practice? The Act itself gives us a perfect example. Let's say A sues B over an agreement and gives B a notice to produce it. B says no. Now A has to prove the contents of that agreement using secondary evidence, maybe a photocopy or oral testimony. Later in the trial, B can't just suddenly pull out the original agreement to challenge A's evidence. And why not? Because B had their chance to produce it earlier and they refused. Simple as that. And this principle applies across all kinds of cases. In a contract dispute, you can't just hide the original agreement. In a property case, if you're asked for the title deed and you don't produce it, you can't rely on it later to prove your ownership. Similarly, in a tax matter, if you hold back records, you lose the right to use those original records to challenge the secondary evidence, like certified copies, that the other side presents. These are classic problem-based questions you can definitely expect in your exams. You know, every legal provision is supported by underlying principles and judicial interpretations. So what are the guiding principles and landmark judgments that give Section 167 its strength? This legal maxim is really the soul of Section 167, Allegans contraria non est audiendas. It means a person making contradictory statements should not be heard. In simple terms, you can't have it both ways. You can't first say, I won't produce this document, and then later demand, now I want to produce this very same document. The law just won't entertain that kind of contradictory argument. And the courts have consistently upheld this principle. In Hiralal v. Badkulal, the court stressed just how important fair disclosure of documents is. And in Kalia v. State of Madhya Pradesh, the court expanded on this, saying that procedural fairness is paramount in all matters of evidence. These cases are basically the judicial stamp of approval on the principles found in Section 167. All right, let's get to the part I know you've all been waiting for. Why is this section such a hot topic for judiciary and APO exams? Let's break down its importance. The evidentiary value of this section is just huge. As you can see from this chart, its main job is to prevent the suppression of evidence and to shut down surprise tactics. It also encourages honest disclosure, supports the use of secondary evidence when the primary is withheld, and ultimately, it ensures fairness in the trial. Understanding these points is the key to writing a high-scoring answer. So here's a direct exam tip for you. For your prelims, you can expect a direct question on the section number or its core concept. For your mains, be prepared for a problem-based question where you'll be given a scenario and asked to explain the consequences of not producing a document after receiving notice. We've covered a lot of ground today. Before we wrap up, let's do a super quick final revision just to make sure the most important points are locked into your memory. So, here are the key takeaways. First, remember, it's Section 167 of the Bharatiya Sakshya Adhiniyam 2023. Second, its core concept is simple. If you refuse to produce a document on notice, you lose the right to use it later. And third, its key principle is to promote fairness and prevent litigation by surprise. This is an incredibly important topic for your exams. And here's something for you to think about. In your opinion, what factors might a court consider when deciding whether to grant that exceptional order of the court? What could be a good enough reason to allow a party to use a document they initially refused to produce? Thinking about this will help you develop a deeper, more nuanced understanding of the law. And that concludes our explainer on Section 167. I really hope this was clear and helpful for your preparation. For more legal content focused on judiciary, APO, and law exams, stay connected with Ganga Education.
And today, we're going to decode a really key provision in our evidence law.
All right, let's kick things off with a question that really gets to the heart of what our courts do. When you picture a judge in a trial, what do you see? Are they just a silent umpire, kind of like in a cricket match, just watching the game play out, or are they an active player right there on the field, making sure justice is actually served? Well, the answer to that is hidden in what we're talking about today.
So today, we're diving into Section 168 of the Bharatiya Sakshya Adhiniyam 2023. This section is all about the huge power a judge has to ask questions and order the production of things in court. And let me tell you, for anyone gearing up for the judiciary or APO exams, this section is an absolute must-know. So, pay close attention.
Okay, so let's look at what the law actually says. Basically, it says a judge can ask any question they think is necessary at any time, for one big reason: to uncover the truth or get proper proof of the facts. In simple words, this section gives the judge some serious power to be proactive in a case.
So, to really get a handle on what this means, we need to break it down, right? Let's deconstruct this power and see what its core principles are.
You can think of the judge's power here in three parts. They can ask any question in any form at any time. The goal is always the same: find out what really happened, to get to the truth. But, and this is a big but, it's not a free-for-all.
This power isn't absolute. There are limits. Like, for example, a judge can't force someone to reveal a privileged communication, like what you tell your lawyer.
So there's a kind of logical flow to how this whole thing works. It all starts with step 1. The judge uses their power to ask questions. Step 2 is the why, the purpose, which is always to discover the truth. But then comes step 3, the really crucial part, the safeguards. This power isn't unlimited. It has checks and balances, like respecting privilege and maintaining judicial fairness, to make sure the process doesn't go off the rails.
You know, there's this great legal maxim that fits perfectly here. Iudex est lex loquens. It literally means the judge is the speaking law. It's a powerful idea, right? It shows that the judge isn't just a passive listener. They are the voice of the law, and their job is to actively seek out the truth. Okay, so that's the theory. But how does this actually play out in a real courtroom? Let's move from the books to the bench and look at some practical examples and a really important case. When we talk about this, there's one landmark case you absolutely have to know. Ram Chander versus the state of Haryana. The Supreme Court made it crystal clear. They said a judge can't just be a silent spectator or a mute umpire. No way. Their duty is to jump in and actively participate in the trial to bring out the truth. This case really cemented the idea of the judge as an active truth seeker. All right, let's imagine a few real-life scenarios. Say a witness on the stand is being really vague or dodging questions. Well, under Section 168, the judge can step right in and ask direct, pointed questions to get a clear answer. Or what if a really important document is missing and neither side has produced it? The judge has the power to order them to bring it to court. But, and I'll say it again, remember the big restriction, privileged communication. The judge can't force a lawyer to reveal what their client told them in confidence. That's a line that can't be crossed.
Okay, now we're at a super important point, especially for all of you studying for exams, so please listen very carefully. The power we're talking about isn't new, but its address has changed. Its section number is different, and we absolutely have to know this legislative update.
This power used to be under Section 165 of the old Indian Evidence Act of 1872, but now, with the new laws, it is moved. It is now Section 168 of the Bharatiya Sakshya Adhiniyam 2023. Let me repeat that because it is critical. It's Section 168 of the BSA 2023. If you write Section 165 in your exam, it will be a major mistake. So please make a note of this. Don't get it wrong. All right, keeping that critical change in mind, let's switch gears and talk about your exam game plan. How do we turn this knowledge into marks? Okay, for your prelims, you're probably going to see a direct question. Something like, which section of the BSA gives a judge the power to put questions? Simple. But for the mains, it gets trickier. You might get a problem-based question where you have to apply this section, or they might ask you to write a short note on the judge's discretionary powers. So you see, you need to know not just what the power is, but also its limits. That's the key.
So let's wrap this up with a quick revision. 3 things you need to walk away with today. First, the section number. What is it? That's right, Section 168 of the Bharatiya Sakshya Adhiniyam 2023. Second, the core idea. It's all about the judge's power to ask questions to find the truth. And third, its exam importance. It's incredibly high. You just can't skip this one.
And there you have it, a deep dive into Section 168. It's such an important provision because it shifts the judge from being just a referee to being an active player in the quest for truth, which is what justice is all about. For more content just like this, aimed at helping you ace your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.